Hi everyone, Dave Sugden of Evidence at Trial. Today we are going to talk about the business records exception to the hearsay rule, a super important exception that trial lawyers and litigators need to know. In fact, I would suggest it's really helpful to memorize the actual elements of the rule. And the reason why is because these issues can come up quick, even in deposition, and the questions that are asked can make the difference between having a record admitted or excluded at trial. So before we get to the actual elements, I do want to talk about both the rationale behind the rule as well as how to get there mentally in terms of when to recognize when the exception applies. So first, the rationale. What does this exception mean? Why does it exist? And the reason we want to know that is because if, for example, you can't remember every element, if you know the reason behind the rule, you can ask questions almost based on intuition, and you can get almost where you need to be. So why does this exception exist? And the reason is that judges want to make sure that the evidence that is making it in as a business record is trustworthy. In other words, if a business has a record that it uses every day prior to knowing that a lawsuit is coming or a lawsuit has been filed, if they use this record every day and they rely on it as part of their business as being true, the judge will be satisfied that this is a trustworthy document. But what if the document was created not in the ordinary course of business, but because this company or organization knew a lawsuit was filed or was going to be filed? And what they were doing is creating a record to memorialize their version of events. A judge would look at that document with a lot more suspicion and be more inclined to exclude it. And so if nothing else, remember that when we're talking about business records, what we're looking at is whether or not the document is trustworthy. So how do we know when to recognize when the exception applies? One way to think about hearsay exceptions is to categorize them, because there are so many exceptions. Rather than thinking, okay, what is every exception? First, think of the categories. And so one way to think of it is first, admissions, prior statements, writings, history. When we think about business records, we're obviously talking about writings. But before you get to writings, also consider these others. So for example, if this record came from a party opponent, you don't have to worry about business records exceptions because it's a party admission. And so in California, you're going to begin that analysis in section 1220 through 1227. And in the FRE, the Federal Rules of Evidence, you're going to be looking at 801D2. In fact, in the federal rules, party admissions are not an exception to the hearsay rule. They're considered not hearsay. So here we're talking about not a party opponent's document, but perhaps our own client or our own party's business record or a third party. We're now talking about writings. And so before we get to business records, it's also helpful to mentally think of what are the other hearsay exceptions that apply when we're talking about writings. And this list can seem a little bit unwieldy, but once you get familiar with it, it's not so bad. And so for example, we have public records, that's in California, section 1280. We have judgments, section 1300. Former testimony, very important, that's section 1290 in California, 801B1 in the federal rules. Now we're talking about business records. So now we understand we're talking about business records, and a way to think of the elements is to break it down into component parts. And so the first thing we want to ask is, what does this business record purport to memorialize? In California, it says that a writing is not made inadmissible by the hearsay rule if it purports to record an act, condition, or event. It's the first thing. Next, we want to see if it's trustworthy. And so how do we do that? We look at how is this record made. And so what the court wants to know is what is identified in subdivision B, and that is, was this document made in the regular course of business? If yes, you keep going. Next is, was it made at or near the time of the act, condition, or event? And the reason why that's important is, again, they want to make sure it's trustworthy. And so if there's some act or event that happens, and then the business decides to memorialize what happens a month later, the court's going to view that with much more suspicion. So it wants to know, when was this record made? Next, it wants to have a custodian or other qualified witness attest to the identity of the document and how it was made, the mode of preparation. And so finally, it looks at, in the final subpart, is, does the method, the information, and the time, all of those components, does it suggest that the document is trustworthy? So you look at those elements to make sure that a business record can be admitted, or you attack it if you want to have it excluded. In the federal rules, it is Rule 8036, and 8037 is the absence, proving the absence of an event when the record doesn't exist. And so in terms of the substance, it's very close. The only differences I want to highlight are, one, in terms of what it can memorialize in federal court. In federal court, it is an act, condition, or event plus. It can also be an opinion or a diagnosis, not in California. And so when you see documents that are, every indication suggests that it's a business record, but it has some type of opinion language in it, in California, you're going to run into challenges. In federal court, it's going to be okay. The other component in the federal rules is that when it comes to the trustworthiness element, in California, if you're the proponent of the document, you have the burden of proving that the document is trustworthy. In the federal rules, the burden is on the other party to prove that the document is untrustworthy. Substantively, not a huge difference, but as practitioners, we want to be aware of it. Finally, a way to visualize this rule can be helpful in this slide. And again, we're talking about the elements of the business record exception, and this can be sort of a helpful way when you're in trial or in an examination, knowing the elements you want to hit when you're examining these witnesses. So again, what are we talking about? In California, we're talking about a document that memorializes the act, an act, condition, or event. We want to then show that it's trustworthy. And so we show that this is made in the regular course of business. It was made at or near the time of the act, condition, or event, and that we have a custodian or qualified witness who will attest to how the document was made. And then what we want to show is that the source, method, and time in which the record was made is trustworthy. Again, in federal court, the only difference is the act, condition, or event. It can also be an opinion or a diagnosis. And when it comes to trustworthy, the opponent of the record has the burden of proving that it's untrustworthy. So there you have it. That's the business records exception to the hearsay rule. It is super important. Folks, I hope this was helpful. If you liked it, please download, rate, review, subscribe to our Evidence at Trial YouTube channel. And if you like this and want to do a real deep dive on these rules and how to apply them well, check out our on-demand courses at evidenceattrial.com. Thanks for watching.